sent you an amended complaint.
I saw that as well. Thank you. All right. All right. Well, if everybody's ready, let's be on the record in case number 2019 CR 983, captioned State of Kansas versus Francisco Hernandez. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
May it please the court, Garrett Solomon on behalf of Mr. Hernandez, who appears in person, sitting next to me while in custody, all via Zoom.
All right. We are here set down for a plea. This case today was scheduled in front of Judge Mahoney for a mediation, and my understanding is the negotiations that took place were fruitful and that we have an agreement we're ready to memorialize today. Do I have that correct?
That is correct.
Yes, Your Honor.
All right. I also reviewed the docket entries, and it appears that a preliminary hearing has been held, so we don't need to address that issue. Am I correct in that as well?
Correct.
Yes, Judge.
All right. Mr. Hernandez, to take up this plea, I'm going to have to ask you a lot of questions, okay? If I ask you something you don't understand, stop me and tell me, and you and I will talk about it until we're sure we're on the same page, okay?
Yes, sir.
All right. If at any time you want to talk to Mr. Solomon in private before you answer one of my questions, just tell us. He'll mute the microphone. You guys can have a conversation and just come back when you're ready, okay?
Yes.
All right. To start this off, I have to have you sworn in. So as best you can, if you can raise your right hand, my court reporter will swear you in.
Excuse me. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right. Mr. Hernandez, how far did you go in school?
GED?
All right. You read and write okay?
Yes.
Is English your primary language?
Yes.
All right. I know you're in custody, but I have to ask you, as you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what we're doing today?
No.
All right. Feel like your mind's clear?
Yes.
All right. Do you know what you're charged with?
Yes.
And you know you don't have to change your plea from not guilty to no contest. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on these charges. Do you understand that?
Yes, sir.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You would not have to prove anything yourself. Mr. Solomon would assist you throughout that trial. He would cross-examine, confront all of the state's witnesses. He would challenge all of their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of the court to make them come to court. You would have a right to testify at that trial, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, Ms. Whitman here couldn't get up and argue to the jury, well, ladies and gentlemen, he must be guilty because he didn't take the stand and tell you his side. You understand all that?
Yes, sir.
Right. Finally, if we had that trial and at the end of that trial you were convicted, you would have a right to appeal that conviction to the appellate courts. If you didn't have money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
All right. Now, if we do this plea today, there's not going to be a trial of any kind in this case, and you're going to be giving up all of those rights that you and I just went over. Do you understand that?
Yes, sir.
I am going to put up on the screen what I received as the plea petition in this case. Can you see that document?
Yes, sir.
All right. And you go up to the top here. Yeah, I know this was done kind of hastily, but is that the plea petition that you and Mr. Solomon went over?
Yes, sir.
All right. Now, there's not a signature on mine, but is it your, if you understand everything in that document and you want to go forward with that plea, I would ask you to put a signature above that word defendant on your copy of the plea petition.
Judge, he's already signed it. He signed it in my presence just a
Okay.
few moments ago.
The court will so know. All right, Mr. Hernandez, I want you to look this with me. I'm going to read to you what I've been told is the plea petition in this, or the plea agreement in this case. It says that you're going to be pleading no contest to the amended complaint, which charges you in count 1 with involuntary manslaughter, which is a level 5 person felony, and the amended count 2, which is a DUI first offense. You're going to agree to serve 34 months on count 1, and the parties will recommend to the court that that be your sentence in count 1. Furthermore, the parties are going to recommend that I run count 2 concurrently with count 1. You're agreeing to pay restitution, the minimum fine of $750 for the DUI, and the KBI fee of $400 for the blood draw. You're going to get credit for all the time that you've been in jail. Mr. Hernandez, is that your understanding of the entire plea agreement?
Yes, sir.
Has anybody promised you anything else besides that to get you to plead guilty to, or no contest today?
No, sir.
All right. Has anybody placed any force or threats against you to make you plead no contest today?
No, sir.
All right. Now, there's some recommendations in here about what your sentence should be, the length of the jail time and whether they should run concurrently or not. You understand, while I listen very closely to all of the comments that everybody will make and all of the recommendations of the lawyers, at the end of the day, I'm not bound by any of those recommendations, and I can give you any sentence that the law allows me to. Do you understand that?
Yes, sir.
All right. I received from Judge Mahoney the criminal history worksheet that seemed to indicate that Mr. Hernandez was an H. I assume that both parties agree that they believe that is accurate.
Judge, I'm not sure it is accurate.
Okay.
Last I heard, they made, we got an amended one. It said he was a G. I have constantly been after the court service person that created that document to get me the information on the conviction that she believes is there, and I have received nothing from her. I believe he's an I, but because I have not received anything from court services that indicates a G.
All right. And Mr. Solomon, I assume that you have that knowledge as well and share the opinion that it's somewhat up in the air still.
Yeah, I fully expect him to be a criminal history score I. It was a shock when it came back that he was anything but an I.
Okay.
And Judge, obviously, the name Francisco Hernandez is, not a unusual name. It's a common name, and so they might be having issues.
Okay. All right. Well, Mr. Hernandez, look, I know that Mr. Solomon and you have talked about what your criminal history might be and where you might fall on our sentencing grid. In fact, I think I can maybe pull up my copy if I have it open. Right there. All right. So the parties think you are an I, which would recommend in a normal case a sentence of 31, 32, or 34 months. Apparently, there's some information out there that says you might be as high as a G, which is 38, 41, or 43 months. Before we do sentencing, I'm going to order a pre-sentence investigation. It's going to be delivered to me and to the parties, and it's going to have all of the information there for them to make that decision. Your attorney will have an opportunity to challenge anything that you don't think is right about it so that they can come up with an accurate score. But until I see that pre-sentence investigation, I personally don't know anything of your criminal history, so I have to advise you what the maximum penalties for these crimes are. Do you understand that?
Yes, sir.
All right. So if you had the very worst criminal history, in count one, you could be subject to up to 136 months in prison and a fine of $100,000. For count two, it's a B misdemeanor. The maximum is 6 months in county jail and a fine of $1,000. That felony conviction would carry 24 months of post-release supervision. Do you understand those are the maximum penalties in these cases? Or in this case?
Yes, sir.
All right. Mr. Hernandez, at this point, do you have any questions for me about anything that you and I have talked about?
No, sir.
All right. And is it your intent to plead no contest at this time?
Yes, sir.
All right. Then I will, Mr. Solomon, do you know any legal reason why your client should not plead no contest?
No, Your Honor.
All right. Then I will ask you, Mr. Hernandez, as to count one of the amended information, which charges you with involuntary manslaughter, DUI, which is a severity level 5 person felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. As to count two of the amended information, charging you with DUI, first conviction, which is a class B non-person misdemeanor?
It's not, yeah,
Right,
it's
it's
not.
not classified.
Right.
All right. An unclassified B, I'm sorry. It is a class B misdemeanor. To that count, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, thank you. I'm going to ask the state to tell me what they think their evidence would be if this case went to trial. I need you to listen closely, because when they're done, given that you've pled no contest, I'm not going to ask you if you agree or disagree with the evidence, but simply whether you understand that's what the state believes they could put on. Okay?
Yes, sir.
Ms. Whitman.
On August 22nd of 2019 at approximately 9:30, a crash occurred in the area of I-70 and North 110th Street in Wyandotte County, Kansas. A trooper identified Francisco Hernandez as the driver of a white Chevy Malibu that caused the crash. Reviewing the scene, it was determined that the Malibu Mr. Hernandez was operating struck the back end of a 2002 van as it was traveling down the middle lane. Mr. Hernandez's vehicle then shot over to the barrier wall, striking it, and then coming back across, hitting a guardrail, overturning and catching fire. The other driver, Douglas Walker, was killed and was dead on the scene. His vehicle skidded off the road. Mr. Hernandez was being tended to by EMS personnel when they observed and noticed a very strong odor of alcoholic beverage coming from him. His eyes were bloodshot, watery, and glazed. His speech was hard to understand and thick and slurred. Mr. Hernandez was transported to KU Medical Center. While there, an officer with Kansas City, Kansas Police Department read the advisory notices to him, and he was asked to give a breath test or a blood test. He refused to submit to the blood test. A search warrant was obtained and blood was drawn from Mr. Hernandez. That blood was submitted to the KBI. They analyzed it and determined his blood alcohol was 0.17. The blood was drawn within 3 hours of the crash. All these events occurred in Wyandotte County, Kansas.
Thank you, Ms. Whitman. Mr. Hernandez, you heard what the prosecutor had to say?
Yes, sir.
Do you understand that if we went to trial today, that's what they believe they could put on as evidence?
Yes, sir.
All right, thank you. Given my review of the entire file, the plea petition, the amended complaint, and the statements of the defendant today, I find that he has freely, voluntarily, intelligently entered into this plea of no contest. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, And I will in fact find that Mr. Hernandez is guilty of count 1, the involuntary manslaughter, and count 2, the DUI first conviction. I'm going to order a pre-sentence investigation be prepared, and I'm going to continue sentencing pending receipt of that. My understanding is everybody is fine with doing this by Zoom. So I have a date available of January 22nd at 1 p.m. in the afternoon. Both lawyers have indicated they are available on that date and time.
Uh-oh, Judge, you're breaking up and froze.
Yep. He's been having that problem. We'll have another one. Oh, I see you moving now, but I don't hear you.
Okay, where did you lose me?
Both lawyers have indicated they're available on that date and time.
All right. To the Walker family, let me express my deepest condolences. You know, we do this a lot, and a lot of times people who find themselves victim of crime have at least put themselves in a position to be so. Obviously, Mr. Walker did not. That makes this even more tragic and unfair. So you have my deepest condolences. At the time of sentencing, I will be happy to hear any comments that you have to say about what your feelings about the case, your loss, and what your opinion of what I should do is. If you want to submit anything in writing, I welcome that as well. I wouldn't necessarily share it with defense counsel, but I would be happy to read that. You can do both if that is what you would like to do, okay? Again, folks, you have my deepest condolences. Other things for our record today.
I know of nothing, Judge.
None from the defense, Your Honor.
Oh, you know what I do? I need to advise the defendant as a convicted felon is prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand that, Mr.
Yes, sir.
Hernandez? All right. And this is not a registration offense, is that correct?
That
Ms.
is correct.
Whitman? It wouldn't fall.
Correct.
Yeah, okay. All right. If there is nothing else, we will be adjourned.
Thank you.
Thank you all.